A very good morning to everybody. Welcome to our webinar. Today we're going to discuss the administration of deceased estates, and more specifically, we're going to focus on the assets in the UK. Our speaker is Luke Marshall. I'll introduce him just now. Let me introduce myself first, and then we can do the rest. I'm Jan Jordaan. I'm a director of Jan L Jordaan Incorporated. Our telephone number, email address, and our website. On the right-hand corner, you can see that this year we're celebrating our 30th anniversary. Last week, the 1st of March, was my anniversary that I've been practicing for my own account for the last 30 years. So welcome everybody. May I introduce our company quickly. We're specialists in administration of deceased estates. We do deceased estates property transfers. We've got a whole department that's doing that. We're also doing wills, and by the way, we're doing wills at no charge. You're always welcome to ask us about that in future. We are also conveyancers. We do transfers of properties, registrations of bonds, cancellation of bonds. We're also on the panel of ABSA, FNB, Nedbank, and Standard Bank. We do trusts, and we also now act as independent trustees. For joining us, house rules, please keep mute yourself the whole time. We have got Jan here that will see to it that everybody is muted the whole time. If there are questions, go to the chat box, ask the question. Once Luke is finished with his presentation, I'll go through the questions and ask Luke the questions, and he will then answer it. Once we're done with that and you feel you want to ask a question, you're more than welcome then to unmute yourself and then ask the question. Luke, thank you so much. Let me introduce Luke quickly. Luke is in the UK as we speak. He studied law at the University of Greenwich in London from 2007 and 2011. He studied his postgraduate diploma in legal practice at BBP Law School, Leeds, in UK, and then started working at Lester Aldridge LLP. LLP stands for Limited Liability Partnership. I'm sure he'll chat about that. He joined them in September 2013, qualified as a solicitor. Here in South Africa, we know it as attorneys in the International Private Client Team in March 2018. And he was promoted to Associate Solicitor in May 2022. So we've made use of Luke's services in the past, and we're very happy. That's the association that we have with Lester Aldridge. And may I encourage everybody that if you do have, if you deal with these matters and you have assets in the UK, please make use of Luke. The last slide will be that you'll see Luke's all these contact details. Right, again, welcome everybody. Luke, it's all yours, my friend.
Yeah, and thank you for the introduction. As I just said, my name is Luke Marshall, and I'm a solicitor at Lester Aldridge LLP, specialising in international cross-border estates. We have 3 firms offices here in the UK. And they're based in London, Southampton, and Bournemouth. I am based in our Bournemouth office on the south coast. So moving on to the presentation itself. During the course of this presentation on UK probate, I'm going to be covering a number of topics. Firstly, starting off with the different international estate services offered by our firm. Then moving on to the jurisdictional scope we have as UK attorneys. The documents required to apply for a UK grant, the UK inheritance tax return, including domicile considerations, the tax threshold, the tax rate, and potential tax exemption available. I'll then cover discuss the requirements to have certain documents legalised or apostilled, and I'll finish up the presentation with a discussion on offshore wills. So now just to quickly cover the different services offered by the International Estates team here at Lester Aldridge. Firstly, starting in the middle is the estate administration in the United Kingdom. This is going to be the focus of our presentation today. More to come during the course of this. Moving clockwise, we regularly assist many clients with estate administrations in Jersey, Guernsey, and the Isle of Man. These are some very popular tax-free havens and can be very lucrative to foreign investors. An important thing to note here is that these islands, Guernsey, Jersey, and the Isle of Man, do not form part of the UK. They are their own independent legal jurisdiction. Unfortunately, we see time and time again used in the UK only, with the intention for it to apply to assets in one of the islands. And unfortunately, in those circumstances, it would not be valid, and you would have to deal with the administration of the island assets on an intestacy basis. We also assist a number of clients with estate administration in mainland Europe. This commonly includes assets in France, Germany, Spain, Italy, regularly bank accounts and stock portfolios. A really popular area of work for us is also the drafting of offshore wills and assisting clients with domicile considerations, which I'll touch upon at the end of this presentation. A big area of our work is North American estate administration. So this includes the USA and Canada, most regularly with share, stock, equity administration. This includes IRS federal tax clearance for US taxable estates, for share transfers and sales. Another limb to our services is preparation of affidavits of English law. And we also have an in-house notary that can assist with any notarial requirements. And finally, another popular area that we are able to offer our clients is assistance with asset administration in Australia and New Zealand. Both of these countries form part of the Colonial Probates Act. So therefore, for example, letters of executive that are issued in South Africa can very easily be resealed in either Australia or New Zealand. Next slide, please.
Luke, can you see the next slide?
I can, thank you very much. So now, just to cover off the jurisdictional scope we have as UK attorneys, jurisdictions that we regularly work in, and they are the United Kingdom, which will be discussed in further detail today. In addition, the Isle of Man, Jersey, Guernsey, France, Italy, Spain, Germany, Switzerland, Luxembourg, the USA, Canada, Australia, and New Zealand. Now, this is not an exhaustive list. There are additional jurisdictions that we can assist clients with asset administration in. So please don't hesitate to contact us if the country falls outside this list. We will usually be able to assist directly, but on the rare occasion that we can't, we are always likely to be able to refer you to an agent within that jurisdiction that can assist you. Next slide, please. So now moving on to the documentary requirements for a UK grant. And this will ultimately depend on whether the executor needs to apply for a testate or testate estates. The executor will be required to prepare and collate a court-sealed and certified copy of the letters of executorship, a court-sealed and certified copy of the will and any codicils, a court-sealed and certified copy of the death certificate, and a signed and witnessed power of attorney if the executor is appointing a UK attorney. And for intestate estates, slightly different documents will generally be required, and these include particulars or an affidavit of kin, an affidavit of law confirming who is beneficially entitled to the UK estate, in certain circumstances, a genealogist report where there's no immediate family, and we need professional assistance in tracking down beneficiaries entitled, court-sealed and certified copy of the death certificate, and a signed and witnessed power of attorney, again, if the executor is a UK attorney. Just thought I'd also important to mention here additional documents that may be required when proving an original will. These include an affidavit of law to confirm the will's validity. For example, if we intend to prove a will in the UK that's been prepared, executed and signed in South Africa, we would require an affidavit of law signed by a qualified South African attorney confirming that the will complies with the internal laws of South Africa. If there's any damage to the will, including rips, tears, or even staple holes, an affidavit of plight and condition may be required from the person responsible for storing the will, just to confirm that it has not been tampered with in any way and no pages have been added or removed. And finally, if any of the executors appointed under the original will do not wish to act, then we will need to have a deed of renunciation signed, which will accompany the application to the UK court. Next slide, please.
If you don't mind, I just want to make sure that I understand it correctly. This is now if you act on behalf of, let's say, anybody in South Africa, or do I get it? Is that what it is?
So these are required either way, whether the executors are applying for the grant directly or they're appointing a UK attorney to assist them. The only additions that are required for a power of attorney to appoint a lawful attorney would be the power of attorney.
Okay, correct.
All other documents are standard.
Thank you.
Thank you. So moving now on to the probate process in the United Kingdom. One of the most fundamental parts of that process is the UK inheritance tax return. And this is a prerequisite to obtaining probate in the UK. And before preparing the UK inheritance tax account, one of the executors' early considerations should be the deceased country of domicile as of date of death. Establishing a person's domicile upon death can be a complex legal consideration, especially when the deceased has lived in multiple countries during their lifetime. Domicile is not always clear-cut and will require a close and careful analysis of the deceased's will, employment history, place of residence, family commitments, and ultimately the deceased's true intentions. If dealing with an estate whereby the deceased died domiciled in the UK, then the executor of the estate will be requested to disclose the deceased's worldwide assets and liabilities to the UK Tax Office, which is Her Majesty's Revenue and Customs, which I will abbreviate to HMRC for the purposes of this presentation. If the deceased died domiciled outside the UK, such as South Africa, for example, then the executor will only be required to disclose the UK situated assets to HMRC. However, it's important a deceased may be caught by the UK deemed domicile rules. So if the deceased has been UK resident for at least 15 out of the last 20 tax years immediately before the year of death, then they'll be caught by the UK deemed domicile rules and their worldwide estate will be reportable to HMRC. It's important to mention here that the UK deemed domicile rules will apply for tax purposes irrespective of the common law domicile, which may be different. Moving on now to the tax threshold currently applicable in the UK. So every individual, irrespective of domicile, nationality, and country of residence, is entitled to a tax-free threshold of £325,000. So this enables anyone to leave assets up to a value of £325,000 to chosen beneficiaries completely free of tax. Should the value of the estate exceed £325,000, then the standard inheritance tax rate of 40% will be applied to the value of the estate over and above this threshold. For example, if dealing with a UK estate valued at £400,000 and no exemptions and reliefs are available, 40% inheritance tax will be applied to the £75,000 which exceed that tax threshold. This would result in a total inheritance tax liability of £30,000. To try and mitigate such tax, the executors will need to carefully consider whether any exemptions or reliefs may be available to the estate. As you'll see on the slide, I've listed the more common exemptions that are regularly claimed in the UK. However, there are some additional exemptions, but just for the purposes of this presentation, I'm going to focus on the most common. So one of the most frequently claimed exemptions is that of spouse exemption. The exemption means that all assets passing on death to a surviving spouse or civil partner are exempt from inheritance tax. In the majority of cases, there is no limit to the value of the estate that can be passed on tax-free to a spouse. However, there is one caveat to this general rule. and that is if the deceased are domiciled in the UK and their spouse or civil partner is domiciled outside the UK, then the spouse exemption is limited to the nil rate band available at the deceased date of death. And as we've just touched upon, this currently stands at £325,000. In addition to the spouse exemption, married couples and civil partners are also able to pass on their unused individual tax-free allowance to their spouse. This provides greater relief on the estate of the surviving spouse. And I'll give you a quick example here, just context. So if Ben dies and leaves his entire estate to his wife Sarah, his full nil rate band remains unused. On Sarah's death, her estate benefits from her personal nil rate band of £325,000, as well as Ben's transferable nil rate band, which is transferred to Sarah's estate on her death. As a result, Sarah's estate benefits from a combined inheritance tax exemption of £650,000. Now, this is a really, really useful exemption and allows for any unused nil rate band to be fully utilised by the surviving spouse. Moving now on to the residence nil rate bands. So under this exemption, where a home is passed on to a direct descendant of the deceased property owner, such as a child, grandchild, or other lineal descendant, the first £175,000 property's value will be exempt from inheritance tax. The inherited doesn't just need to be a child or grandchild. This also covers stepchildren, adopted children, and foster children. This exemption can only be used for one residential property. If the deceased had more than one residence, only one of those properties can qualify for the relief. The property does not have to be the main family home, but it must at some point have been the residence of the deceased. This means that most buy-to-let properties, for example, by finance houses in London, and the deceased are domiciled in South Africa. This stock portfolio may contain 20 different stocks and shares, so we must look under the wrapper of the portfolio and identify the individual underlying stocks and shares. Out of these 20, let's say 10 are cited and incorporated in the UK, and the other 10 are cited and incorporated in the United States. Under the exemption of foreign property, we will be able to deduct the value of the US cited stock from the UK inheritance tax calculation. The next category under excluded property is certain holdings in investments, and these include holdings in open-ended investment companies and authorised unit trusts. These types of investments are considered excluded property, again, if the deceased died domiciled outside of the UK. And the final category under excluded property is certain government securities, and this includes bonds and gilts, and these are considered excluded for inheritance tax purposes, again, provided that the deceased died domiciled outside of the UK. Moving now on to the relief of business property relief, and this is a relief that enables certain type of business assets to be transferred to a beneficiary with a 50% or 100% reduction in inheritance tax. Business relief is available to trading businesses only, as opposed to those dealing in stocks and shares, letting of property, and the holding and making of investments. HMRC guidance stipulates that a business is trading if at least 50% of its activity is trading activity and less than 50% is investment activity. It's important to remember here that businesses either qualify for business relief in its entirety or not at all. In all cases, business relief applies only where the deceased has owned the assets for at least 2 years. Assets that qualify for 100% business relief include shares in an unlisted public limited company, shares in a private limited company, and shares listed on an alternative investment market. Assets that qualify for 50% business relief include shares that control more than 50% of voting rights in a listed public limited company, or building, land, or machinery used as part of a business and the deceased had an interest in that business. And finally, the last exemption I'm going to cover is that of agricultural relief. And this enables anyone to pass on agricultural property free of inheritance tax as part of a will. Property that qualifies for agricultural relief is land or pasture that is used to grow crops or to rear animals intensively. To qualify for this relief, property must be part of a working farm within the UK, and the property must have been owned or occupied for agricultural purposes before death for a minimum of 2 years if occupied by the owner, or 7 years if occupied by someone else. Agricultural relief is due at either 50% or 100%, depending on the circumstances. And the last topic for this slide is the tax deadline. This should be an important consideration for any executor, and they should try and identify whether tax will be payable as early as possible. The tax deadline is 6 months following the date of death. For example, if a person dies in January 2023, for example, inheritance tax must be paid by the executor by the 31st of July 2023. So this tax timescale works from the end of the calendar month of death and for a full 6 months thereafter. Payments made after the 6-month deadline will be subject to interest and possible fines. Interest is typically calculated at 3 to 4% of the tax liability amount per annum. Next slide, please. Now moving on to the physical application process itself. And we're going to be looking at the physical and procedural process involved in applying for a grant. And the type of application that's required for executor will ultimately depend on whether the deceased died testate or intestate. For testate estates where the deceased left a will, probate application form PA1P will be required. And for intestate estates where the deceased died without a will, probate application form PA1A will be required. Historically, resealing was a fast and efficient way to obtain recognition of a foreign probate document by the English Probate Registry, which would then enable the executor or their attorney to gain access to assets registered in England. The English court is permitted to reseal documents issued by the courts of specified current and former Commonwealth countries and territories. Common examples include South Africa, states throughout Australia, New Zealand, and certain provinces in Canada. One of the historical advantages of resealing was that there was no need for an oath, later known as a statement of truth, which helped expedite the reseal process. Unfortunately, the historical advantages were washed away by the introduction of forms PA1P and PA1A. For example, the guidance notes for form PA1P show that if applying for a reseal, you must now prepare and submit a formal probate application, which historically was not the case. Over recent years, I can no longer see any advantage to resealing a foreign grant, such as Lester executorship issued in South Africa. Why would you if it takes the same amount of work to apply for a full grant? Also, a full grant provides an even more recognisable and familiar court document for the UK asset holder, who are often bewildered with the strange creature that is a reseal. To add to the heartbreak, we're now finding that many reseal applications take far longer than ordinary grant applications and are often not dealt with correctly by probate registries. It feels like a once cherished tool for the cross-border probate practitioner has now been rendered obsolete. Rule 30 of the Non-Contentious Probate Rules 1987 applies to grants where the deceased died domiciled outside of the UK and governs the basis on which an overseas executor or beneficiary can apply for a UK grant. There are 3 main grounds for application. Firstly, under Rule 31A, a grant can be issued to a person entrusted in the deceased country of domicile by the court having jurisdiction where the deceased died. This will be applicable when dealing with a worldwide will which has been proved in South Africa and letters of executorship have been issued. The person named on the South African letter of executorship would constitute the person entrusted in the country of domicile. Under Rule 31B, where there is no person so entrusted, a grant can be issued to the person beneficially entitled to the estate by the law of the place where the deceased are domiciled. This provision would be applicable in most intestacy cases. And finally, under Rule 33AI, the grant can be issued to an executor named in a will. This would be applicable when dealing with an original worldwide will or a separate offshore will, and the executor is proving that original will as part of the UK probate application. Moving now on to the validity of wills. So Section 1 of the Wills Act here in the UK governs validity. Under this legislation, a will should be treated as properly executed if its execution conformed to the internal law in force in either the territory where it was executed or in the territory where the testator was domiciled or had his habitual residence, or where the testator was a national. As you'll see, this section provides many different opportunities to demonstrate that a will is valid. Demonstrating that a will conforms to the internal law of a foreign jurisdiction will require evidence from a suitably qualified lawyer in that jurisdiction. Depending on that jurisdiction, this can sometimes be expensive and time-consuming. Previously, affidavit evidence was required. However, in order to alleviate the difficulty of swearing affidavits, the President of the Family Division here in the UK recently issued guidance to allow statements of truth to be substituted for affidavits. This has been codified in the non-contentious probate rules to allow a witness statement as an alternative to an affidavit. This certainly makes life a lot easier for many UK probate practitioners. For most South African clients, when looking to prove an original will in the UK, a witness statement signed by a qualified South African attorney confirming that the will was signed and executed in accordance with South African law will generally be accepted by the UK courts. A statement which establishes the facts made by a notary practicing in the country of the deceased domicile will also be widely accepted without any further question. And the final topic for this slide is will in a foreign language. So where the will is in a foreign language, a translation of that will and any codicil must be lodged together with the UK probate application. The translation will be lodged alongside the original will or a court seal copy of the will. A translation verified by a notary public or a British consul will be accepted without verification being required. Where an English notarial or consular translation is not obtained, and the translator is not a person whose competency is vouched for by an official position, an affidavit or witness statement by the translator as to their qualifications will generally be required. Just to give you an example of how strict the UK courts can be on this, I once submitted a translation of a will prepared in Afrikaans. The translation was prepared by a court-appointed translator and contained details of the translator's qualifications and certification stamps. Given the official position of the translator, I wrongly assumed that the probate registry would accept this. I was later informed that affidavit would be required from the translator. Nowadays, my view is that this was overly cautious from the registry. Now that witness statements are being accepted, this should make this requirement less burdensome. And in most cases, a translation prepared by the High Court or a court-appointed translator in South Africa will generally suffice. And just finally, before we move on from this slide, I wanted to touch upon processing timescales here in the UK for probate applications. Like most of the world, we are suffering from severe delays at the moment. Pre-pandemic, we are currently looking at a turnaround time on probate of around 6 weeks. Post-pandemic, unfortunately, our probate registries are very backlogged, short-staffed, and overworked. And the issue of probate current turnaround time is generally 4 to 6 months. So a real substantial increase there in turnaround times. Next slide, please. So now I'm going to touch upon the necessity of having certain documents legalized or apostilled, and this will only apply in quite limited cases. and generally when administering assets in civil law jurisdictions. The most common ones that we assist with are countries' assets which are held in Switzerland, Luxembourg, or Germany. Civil law jurisdictions rely on a codified system where core principles are written into a referable document. Common law jurisdictions, on the other hand, such as England and Wales, rely on case law and the development of precedents set by judges. I've also attached a copy of an apostille to the right of the slide, just to give you an example. If working with our firm, with the administration of assets in a civil law jurisdiction, we will try and outline from the outset if any documents need to be legalized or apostilled, or again, if the executors decide to work directly with the asset holder will advise them of these requirements from the outset. Important to note here that legalized and apostilled documents will not be accepted by the UK courts for a probate application. As we've discussed earlier in this presentation, for the purposes of UK probate, all documents have to be court sealed and certified. Next slide, please. Moving on now to our final topic, and that is of offshore wills. I have many clients come to me and ask for recommendations as to whether one worldwide will should suffice or whether multiple wills should be prepared for a testator. And this will ultimately depend on the testator's personal circumstances. So I'm now going to run through a number of examples where more than one will would be recommended. So the first example is where an individual is domiciled in South Africa and the only offshore asset is a bank account registered in England. In this instance, the will draftsman should consider what formalities will be if the testator passes away to administer the bank account in England. Each bank in England has their own threshold in which they will release the funds without wishing to see an English court authority. And on average, this is approximately between £10,000 and £30,000. So if the funds are over the bank's relevant threshold, an English court authority will be required. So in this case, the will draftsman may consider that one worldwide will is appropriate. The only drawback is that the South African administration and English administration cannot be conducted simultaneously. Before the will and letter of executorship can be used to apply for the UK grant, court sealed and certified copies will firstly have to be obtained, which in this current climate can take many months. Moving now on to the case for a domicile will and a will outside of the jurisdiction. So this example is that of an individual who is domiciled in South Africa, but also owns an investment portfolio in Jersey, a bank account in the Isle of Man, and stocks and shares in the UK. In this example, the assets are located in 4 different legal jurisdictions. Preparing 4 wills could be quite a messy and dangerous exercise and not appropriate in these circumstances. A practical solution would be to have the domicile will limited to South Africa only. In addition, there should be an offshore will which applies to all jurisdictions outside of South Africa. The offshore will could then be used to administer the assets in Jersey, the Isle of Man, and the UK. The main advantage of this would be simultaneous administrations, which would help expedite the offshore estate administrations. And now the final case example would be a case for a worldwide will and a separate will limited to one jurisdiction. This final example is where an individual is domiciled in South Africa, but an Italian national and owns a holiday home in Italy, which is a civil law jurisdiction. In this example, alarm bells should be ringing for the will draftsman in South Africa, as there may possibly, depending on the family, be forced heirship rights to consider. Also, where a movable property is owned abroad, an offshore will is almost always advisable, and where forced heirship rights may arise, vitally necessary. This may be because the foreign jurisdiction will only recognise a local will to dispose of property in their jurisdiction, or because an offshore will can give authority and be used in a more timely fashion, which will then enable the executor to deal with the property more efficiently. In this example, it would be appropriate for the South African will draftsman to prepare a worldwide will excluding Italy, and at the same time advise the client that they must have an Italian will dealing with their Italian estate only, drawn up by an Italian practitioner. Next slide, please. This would conclude my presentation. I appreciate it was somewhat of a whirlwind stop into the UK probate application process, but I hope you all enjoyed it and found it informative.
Thank you, Luke. Much appreciated. I just want to make sure you can hear me.
Yes.
Yes, Luke, are we going to go through the chat box and see? I see there are a few questions. Possible to receive the slides by email? Yes, it will be. We'll send it out. Just request it from us, please. Could you forward the UK domicile consideration? Luke, I'm not sure what that question is. From Shannon, could you forward the UK domicile consideration?
It's something I've discussed during the course of the presentation. I mean, if they had any specific questions for a particular estate, I'd be happy to take a look if they wanted to drop me an email.
Okay, wonderful. Then Mariska, how will one determine if shares are CITES stock?
So this requires a careful analysis. Identifying the CITES, domicile, or incorporation of a stock is vital when reporting the estate and paying taxes, especially in the UK. This information can be obtained from the stock company's incorporation documents, such as a prospectus or articles of incorporation. Stockbrokers or the asset holder themselves can also assist with this exercise.
Thank you. Is it possible to get a recording of the webinar? Yes, we have recorded it. Just request it via email from us, please. Then Shannon, I can't, yeah, there she is. Shannon, once a grant of probate has been granted in favor of a South African executor, how does the South African executor go about opening a UK-based deceased estate bank account?
Every bank will have their own requirements, and it is quite a high threshold, unfortunately, for overseas clients. Some banks may be willing to do this with high due diligence. Others, unfortunately, may not be willing to do so. But most banks are happy to remit funds to an estate account overseas. So if it's easier to open an estate account in South Africa, for example, then most UK asset holders can remit funds overseas. The requirements of each individual bank will vary, though, so you need to make inquiries directly whichever preferred bank you'd like to open an estate account with.
Luke, is that something that you can assist with?
Unfortunately not. We have strict data protection and confidentiality rules here in the UK, so banks will only work directly with the intended opener regarding a bank account opening. From experience, the banks that people they don't really work with emails. Is that true or not? No, unfortunately, a lot of the banks here in the UK. So how do you go about to communicate with them if they won't accept emails? It's mainly by post. Some banks do have email services, but in the first instance, a postal service would always be recommended. Why would they not want to work with emails, Luke? It's just the bank's preference. I think staff issues, I think with the post it's easy to control. Some banks do, some banks insist on postal correspondence only. Okay. Shannon, I hope we've answered your question. Thank you. Cost of drawing up wills. Jolene, you can chat to me afterwards. We don't charge a fee. Maybe that's addressed at you, Luke. What's the cost of drawing up a will in the UK? Okay, so for offshore wills, which were limited, for example, outside of South Africa, our fees start from £700. So again? For offshore wills limited for use outside of South Africa, for example, our firm's fees start from £700. £700. Okay, then next question is Tamarin. What is considered court sealed and certified? So this is the verification by the high courts in South Africa. There will usually be a covering page which identifies which documents have been sealed and certified. It's usually bound with red ribbon, and it will contain a red court seal down in the bottom left-hand corner. And this is what the UK courts will consider as court sealed and certified from the courts in South Africa.
Well done, and thank you, Luke Marshall and Jan Jordaan, for organizing this webinar. Impressive and informative. Very informative. Thank you. Thank you, everybody. If there are any other questions, please unmute yourself, and then let's ask Luke the questions you want. On the left-hand side of your screen, you can see Luke's contact details, his email address, and his telephone number. So you're all welcome. Shannon, you want to ask a question?
Yes, thank you. Luke, if an SA executive has been given a grant of probate, can they appoint your company to assist as co-administrator with winding up the UK estate and UK assets?
I'm so sorry, I didn't quite catch that.
Yeah, the sound isn't good there, Shannon. Just repeat that, please.
Okay. If an SA executive has been given a grant of probate, can the SA executive appoint your company to assist with the administration and winding up of the UK estate?
Okay, so I think I caught most of that. So if a South African executor has had a UK grant issued in their name, can they appoint a UK attorney to assist with the administration? They can, but it's not the preferable route. So if a South African executor is looking for assistance through a UK attorney to assist them with the UK aspect, we would ordinarily be appointed pre-probate under power of attorney, and then I, for example, would apply for the grant on the executor's behalf, and I would attend to the administration directly. The grant would be issued in my name, and I would be effectively stepping into the shoes of the South African executor, carrying out the UK estate administration work on their behalf. If, however, you would prefer for the UK grant to be issued in the South African executor's name, we can assist with the administration after the grant has been issued, but this can be quite complex with the asset holders, as they will only generally recognise the person appointed on the UK grant. So if this isn't a member of our firm, it can be quite difficult. I hope that answers your question.
Yes, thank you.
You're welcome.
Sorry, Tamarin, I see there's a Natasha Lowe gave you the answer to your question. Hopefully that helps you. Then from Trevor, what is the leading book on admin of estates in the UK? Something like a Meyerowitz. We've got a book that we always use, Luke, called Meyerowitz, or the author's Meyerowitz. Is there anything that you can recommend in the UK?
Yeah, so the holy grail for probate practitioners here in the UK is a book called Tristram and Cootes Probate Practice. And this is updated on a regular basis with all new UK probate legislation. And if it's not something that I know, then it is a handy tool that I go to in the first instance. So
just repeat the name of the book, please.
Tristram and Cootes Probate Practice.
Thank you. Then please confirm all costs, including death duties, your costs, etc., must be paid from other funds. From Jamie.
So I assume that's if our firm are instructed to assist a South African executor with the UK administration. So our fees do vary, and they will ultimately depend on the complexity of the estate administration and also the value of the assets in question. Our fees do start from £1,500 for a simple, straightforward grant.
Okay. Thank you. Then I see somebody asked about CBDI points, if we'll get a certificate, any chances of CBD certificates? Yes, we will. We will forward it to you. Maybe request it from us as well to make sure that we do send it to you. Are there any other questions? It looks like there's another question, Luke. What caused Luke to special? Just curious from
I do appreciate the question. In the UK, what I do is quite a niche area of law.
Can you hear me?
Yeah.
Russia, it looks like he's hanging. I can't see. There you are, sir. You're back. Did you see the last question?
I did, yes. Thank you for the question. So yes, international estate work and cross-border estate work is quite a niche area in the UK. We don't have many competitors here. We do have somewhat of a monopoly over the market. Why did I choose to specialise in it? I love the variety. I find it really interesting. Every day I learn something new. And every day is different. I could be working on an estate administration in Canada one day, to Italy the next, to Germany the next. So I love the different variety. Every day is different.
Wonderful. Thank you, Luke. I see Trevor's asking for a recording with his email address. Trevor, we'll do that, but do me a favor, just request it via email, and then we will send it to you as well. And then I see it says buy a donkey. Marcia, Luke, that's just a bit of a tongue in the cheek. That's the direct translation of saying the word buy a donkey. It means thank you.
Oh, okay.
I taught Luke when we met the first time the word lekker. So Luke, this was a lekker presentation. We really appreciate it.
Good. Thank you very much for having me.
Thank you everybody for attending. Just before you go, the 22nd of March, we've got another webinar. The speaker will be Fia van der Spey, the author of the book called Demystifying Trusts in South Africa. She's going to share her knowledge all about the independent trustee. So if you're interested in that, please register for that, and then we'll see each other on the 22nd of March. Luke, thank you so much. We appreciate it.
Yeah, thank you for having me. Pleasure.
Have a wonderful day.
Thank you. You too.
Thank you. Cheers, everybody.
Take care.